Can you tell me a little bit about patent trolls? Marta and I also talked about this for a little bit, and it's really interesting to me. It kind of reminded, if I had it correctly, it kind of reminded me a little bit of like ambulance chasers a little bit.
I'm
Is that
not
right?
going to use that term.
I won't make you the
People
lawyer.
Don't use the term troll, so it's back to your question.
Oh, they don't.
About
Is that like a...
Well, people use it, but I think there are people who think it's pejorative, and maybe properly so, for this reason. The notion that a small entity who's attempting to recapture the value from their invention by targeting many large companies should not be by definition a troll. The mere fact that but people see that sometimes the mere fact that you're not practicing your invention makes you a troll. That shouldn't be the standard.
Oh, okay. And is that what they mean by non-practicing entities?
That's non-practicing entities. Some people use those terms interchangeably, right?
I see. Oh, and you're saying they're not necessarily.
Well, they often are, but they don't have to be, and right. And so just to take a little bit out of the maybe the sting or the bite out of the term troll, you can think about a non-practicing entity that is not misusing their patent, is not targeting. For example, sometimes the use of patents to target what I would call loosely downstream users, where you know very well that the person, to the extent that what you created is a technology and it's being used by a large company, the fact that you're going after their customers because that's how you get to large numbers is, well, that's sometimes not the most fair tactic. Let's just say that.
Could you actually give a specific example of this?
I give, like a mobile app, a mobile banking app. I'll give you one because it's a case we were in. And so the technology at issue was related to semiconductor chips and the way in which they implemented security on the integrated circuit chip itself and methods for doing that. So that turned into a lawsuit against banks because all of the mobile banking applications are on a smartphone. The smartphone has a chip, and the chip has to be employed in some way in order to execute the secure transactions that a mobile banking application was. Pretty attenuated, if you think about it, right? Why is a patent directed to the security on a particular integrated circuit chip, a processor chip, which it's embedded in a phone that is being used by a mobile banking application by a customer who has no idea and doesn't care that a particular processor is riding on their phone that may actually be called upon to do some of the computations necessary for me to do my, I don't know, transfer money between my bank accounts, right?
And who was doing the suing? The chip company?
The chip company, yeah.
And you're defending, I'm assuming, or who are you defending?
The bank in that instance.
Because they were using the chip for their
right. So that's. I say that to say, and probably troll is not the right term, but that's an instance where you could see technology that would be, if that had been someone who, other than a company who was later trying to enforce their patents. But if that had been someone who had never implemented that technology but had gotten a patent and then was targeting banks in that way, that's often what people refer to as trolls. And that happens in retail. You see large cases where they're going after everyone based on, say, the use of some e-commerce based technology. They're going after every retail store that maybe delivers information on the app. And the basic technology is something that the end users don't much care about. Even the stores are buying the technology from someone else who really is the person who is primarily generating value from the technology. Let's just say that. Does that make sense? I know it's a bit convoluted. Which is why discussing trolls gets complicated.
I had thought maybe it wasn't with Marta. I thought it was with Marta, but I thought there were some like entities out there, or even like lawyers or law firms or something where they were specifically targeting. They were like acquiring old patents or something like that.
Sure. So that's a form of a patent troll. So that's different than,
maybe that's more along the lines of what I was thinking.
Yeah, that's different than, say, this just a non-practicing entity. That's basically lawyers who buy a patent in order to assert them and basically shake down people.
Shake down people.
Yeah.
Right.
Yeah.
Right. So that does happen.
That does happen.
Do you think that's growing because of this boom?
I think that's leveling off. I think for a couple of reasons. I mentioned some of the cases that have limited how much you can get patents on a fundamental economic method or fundamental business method if you haven't improved the technology. Well, for a while there were a lot of patents that could issue that way, and those patents right now are nearly impossible to enforce. And so patents like that for a while were generating a lot of cases for these kind of they could buy up these patents fairly cheaply and enforce them, of course, across a broad number of users. Now it's harder to do that, right? Because you can assert that patent, but it's probably not going to stand up to a challenge of its validity. Because you can challenge the validity of an issued patent on the number, on the fact that what this would be, that it wasn't eligible to be patented in the first place. There are other reasons too, that somebody else did it, that it wasn't novel. So to your question of whether, I think your question was, is that leveling off, or is there more of it? And I think right now, that's probably leveling off, but I don't think it ever goes away, because there is, it is a little, I wouldn't say ambulance chaser, it's probably more akin to the, to things like products liability suits and all, where there's just a fundamental level of it that, it's based on the cost of litigation, and that people will pay for litigation to go away, right?
Right. Doing kind of fast, small settlements.
Yeah.
Because businesses don't want to go to court, whatever.
And it's not worth it for something that seems like it could go away pretty quickly.
Right. Hey everyone, thanks so much for watching the episode. If you're interested in contributing to the conversation and supporting the show, there's 2 easy things you can do. 1, click subscribe, and 2, visit our Patreon page where you get exclusive access to the Exploring Minds community.